What do you do for a living?
I am the should-be president of the United People's Congress.
Sorry?
I am the should-be president of the United People's Congress.
What do you mean should be? You either are or you're not.
No, your owner is an active member of the Uganda People's Congress, and that political party unfortunately has around three rival leaderships, and he is one of the leaderships. So he's a person very vested in the affairs of this country. That's what he means.
But that is not a job. What do you do for a living?
And he's an activist.
An activist?
Yes, this is his day job, Uganda People's Congress, and his affairs. And it's what he's involved with.
You can have a seat, sir.
I honor our other proposed surety is Ambassador Sarah Bireete. Your Honor, we have applauded. She's a resident of Nakasero 2 Parish, Kampala Central. We have applauded her letter of introduction from my LC1 chairperson. She's a resident of Nakasero 2 Parish, Kampala Central. We have also applauded a copy of her passport. Your Honor, she's a retired ambassador of Uganda to the United States, some other countries which she served in diplomatic service. She's a person of great reputation and responsibility. And she has put her name on the line. She's a friend of the applicant. She knows the applicant very well. And the fact that the applicant is ready to come to attend this court and face trial as and when required.
Hello, what is your telephone number?
0782 931 950
950.
50.
Your Honor,
You can have a seat.
Your Honor, I have duly guided the sureties on their obligations to this court. I have duly guided the sureties on their obligations to this court. That they have a duty to ensure the attendance of the applicant before court whenever she is required. I have also guided them that they have a duty to inform the court whenever the accused person is not able to attend court due to some circumstances. Your Honor, the sureties are ready and willing to sign the bail bond form on whatever terms this court deems fit to impose on the applicant. Your Honor, lastly, I have taken note of two important things. First of all, the state has communicated that investigations are still ongoing and are not complete. Therefore, we don't even have an idea of when a trial will take place over this charge. Your Honor, the accused stands charged with the unlawful obtaining or disclosing of personal data. Unlawful obtaining or disclosing of personal data. it's alleged she shared some information that of course is not disclosed without consent of the electoral commission. This is a document-based offense. Your Honor, this is a document-based offense, and therefore the applicant has nothing to do with this sort of offense. There are no witnesses to tamper with. Either she disclosed data or she did not. Either the data exists or it does not exist. And by the time the state has laid the charge, we are entitled to presume that yes, the state has already found out this. And therefore, there is nothing the applicant could interfere with in any way. And therefore, Your Honor, this is an applicant who is entitled to benefit from the presumption of innocence and be permitted to answer to this charge while she is not in custody. And be permitted to answer to this charge while she is not in custody. I therefore pray Your Honor that this court be pleased to release the applicant on bail on such terms as the court deems fit. I so pray Your Honor.
Your Worship, we are not ready to make a reply right now. We seek an adjournment. Analyze the application and make a befitting response. Your Worship. If it pleases this court, we seek for time. Reply.
Your Honor, in regard to the state's prayer for an adjournment, we say two things. First of all, the court has discretion to grant bail. And the input of the state would generally be required at the time they are charging the applicant. Your Honor, it is a practice. It is a practice for investigating officers at the point of laying a charge to file an affidavit in opposition if there is anything that would militate against grant of bail. There is no such opposition. And the applicant has been in police custody. As Your Honor, therefore, would pray that that prayer is overruled and this court proceeds to determine the bail application. However, in the alternative, we are willing to concede to this matter being stood over up to 3 p.m. for the state to make a response. Your Honor, thank God for technology, national IDs, passports, all these, the state has an electronic database. It's a matter of the state going on a computer and logging in, and they will know that, oh, this document is authentic, this one is not. Very simple. And therefore, Your Honor, if the court is so inclined not to grant our first prayer, though we strongly think this is a matter where there is no need for any other delay. The state has had ample time and the accused in their custody. There is no opposition to bail from the investigating officer. That's sufficient to show us that there is no objection. As we have indicated, Your Honor, the accused person is a hypertension patient, and therefore it would be unfair for technical delays to compromise her health further. When ultimately the purpose of the trial is for the accused to be put on trial, and therefore bail is not something where we need to go into very complicated legal arguments and investigations and discoveries. Therefore, Your Honor, would pray that the objection is overruled, but if the court is so inclined, we concede to this matter being stood over up to 3 p.m. for the state to respond and for the court to determine the matter. Mindful that the accused has been in custody since the 30th of December 2025.
The prosecution too deserves the right to make a reply to the bail application, this being a case that has been brought to court by them. Prosecution is granted time to prepare a reply to this application. The application shall be revisited on the 21st of January 2026. The accused person will be kept on remand till then.
Okay, I have very little time, I'm running away, so let's first, I want to make one brief statement which will cover all of you. Eh? Ha. Uganda will be tricky. Kubanga mu Ruganda data protection mu Ruganda bakyeta ki? So what do you want me to tell you in summary? What do you want to tell me to tell in summary?
What was the case about? What he was being charged of? And what was the decision of the court? What is the implication?
Okay. That covers everybody, right? Yes. Fine. Dr. Sarah Bireete has been charged with the offense of unlawful obtaining or disclosing of personal data contrary to Section 35 of the Data Protection and Privacy Act. The state has indicated that investigations are still ongoing. We therefore applied for bail and presented substantial sureties. And the state prosecutor indicated that she needed time to respond to our bail application. And to our great shock and surprise, the court has adjourned the matter to the 21st of January 2026 for the state to respond. In other words, the state has been given a whopping 20 days to respond to a bail application. I've never seen such a situation where the state needs 20 days to respond to a bail application, and it's very unfortunate. It contravenes the Constitution, even the bail guidelines, which were enacted by the Chief Justice, that bail application should be handled in a timely manner, and therefore we are disappointed that the court has granted a very lengthy and obviously unnecessary adjournment for the state to respond to a bail application. And therefore, as far as we are concerned, our client, Dr. Sarah Bireete, has been sentenced to 20 days of imprisonment. We cannot call this ordinary remand. This is a sentence that does not involve due process. Our client has been sentenced to 20 days imprisonment until the 21st of January.
It's very unfortunate. From the 30th day of December, that was last week, everything was wrong with the arrest. We saw police, attack her home, arrest her. In fact, it was more of an abduction. They took her to Natete police station. They are telling us the file is at CPS being handled by KMP. We tried to follow up with police because we were sure they would not be able to produce her in court within 48 hours. And at least she has a right to police bond. It was clear that they're not going to grant her bond. The only thing was we shall produce her in court. It was also very clear that at that time they were not even sure the charges that they were going to put on her. So today they produce her in court and we are saying maybe there might be, let's remain hopeful. But these are the things we've been talking about. We've been saying all these institutions are completely dead, from police to DPP to judiciary. Because under normal circumstances, there's no way you can explain that someone has made a bail application and the state prosecutor is saying that I need time to respond. And then the judicial officer is giving them 21 days. What is that? What does that imply? We've been talking about independence of the judiciary. We've been saying every other day that now we have what we call a police prison pipeline, where it is a must the person who is produced in court, they must be sent to prison as long as the powers that be want that person to be kept in prison. There's no reason as to why Sarah Bireete should be remanded to prison right now. We are talking about prison congestion. There are so many people in prison. There's no space. But you're seeing people like Sarah. Even the charge they put on her that she has shared information, under the Data Protection Act. Sarah has not killed a person. It is not an offense that is that bad, that her being outside, having her freedom, will be affected, or the case will be affected in any way. First of all, the state says the investigations are still ongoing. So if the investigations are still ongoing in the first place, how do you arrest the person? You've arraigned them in court. Why do you even have to object? She did not object, but under normal circumstances, she's saying, I want an adjournment, I cannot respond now. Why is it that the law is not applied, equally? Why is it that the judicial officers, the court, does not favor the citizens? It rather, it's like they're working in the interest of the state. It's what the state wants. And this is a clarion call to all Ugandans. The clarion call to all the members. On behalf of the Ugandan society, really, I must say we are very disappointed in the judiciary itself. Judicial officers are lawyers like us. But the fact that judicial officers are being used by the state to abuse the rights of citizens is so absurd. And it's a shame to all of us. We need to do better. As the National Bar Association, we really condemn that in the strongest terms possible, and we call upon the judiciary to step up and be different. Let them do their duty. Let them do what they're supposed to be done, why they are sent there, why they're taking taxpayers' money. It is such a shame that a simple thing like that, we are finding the state, because Sarah has to be inside prison, they are using these same channels. The institutions that should be protecting the citizens are the same that are being used to trample on their rights. So we are very disappointed. We are not comfortable with what is happening. And again, I'll repeat this, we've seen this happen today. Today is Sarah, tomorrow it will be someone else. At the end of the day, we have the institutions that do not work, that do not follow the human rights-based approach, but rather persecution.
Following the arrest of my sister, we've been waiting for court. Finally, the illegality was now coming to a conclusion and they bring her to court. But I want to tell you for the first time now, in my heart, I'm regretting why I fought for women to be set free. To go and sit in a court and be a judge or a magistrate, and you judge like the way I have seen. I've never seen this. Now, here was the case. I don't even understand the charge. I don't even know the complainant. No wonder the public prosecution did not have anything to say. No wonder. The DPP, isn't that DPP? Yes. They are supposed to be the prosecutors. But the case they are bringing forward is that our Sarah revealed information for electoral commission or something without without the consent. So now question is, who is the complainant in this case? And now when we came to apply for the bail, we applied and gave everything, and we have distinguished, sureties and everything was available, and the prosecutor stand up, he doesn't object. She didn't object to bail. And she's also a woman, Vanange. These young women. She didn't object to bail. And then what happens? The magistrate says, no, I'm not giving bail to you until 21st January. You know what that means? Sarah has been arrested to be shut down in a prison until elections. It was very clear, isn't that so? Nobody objected to granting of the bail. If I'm in a court seated there to judge justly and fairly, and somebody applies for bail, and the one who is accusing does not say, I object to the grant of this bail. Now me as a judge, how do I rule and reject the grant of bail? I don't understand. I tell you, I've been telling you, the systems are shut down. I've been telling you just, and I looked at this cigar, I stood there. I wanted her to see my face. She never opened her eyes up to see me. I don't know what I would have done if she looked at me. Maybe I would have been arrested in this court, because I would have said, very silly, you have no right to sit and judge, because you don't have the integrity to judge. Now
all of us are concerned about the unlawful detention of Dr. Sarah Bireete. I've interacted with her this morning, and our president also spoke to her on phone. She told us that she got information that they are really arresting her so that they make sure she's not in saturation by the time we have elections, that they are very worried about what she has been saying about the different loopholes in the electoral process. You can see the ridiculous charges they are putting on her, that she shared, obtained information about the electoral, voters' details and all that. But you all know that this information is public. Usually the Electoral Commission gives all political parties the voters' register, and therefore it becomes a public document. So if NUP gets a document of that nature, and then different people, for example, many people have been coming to us and requesting for a copy, and we've been giving it to everybody who comes, because this document is a public document. How can you say that someone is releasing data illegally or something like that? So we condemn that in the strongest terms possible. Of course, all these are signs that the regime is afraid of the people and of what is coming, because they know they cannot win a free and fair election.
Back on the